Hello. In this clip from our Justia webinar, Navigating and Mitigating Ethical Conflicts in Estate Administration and Planning, Leah Del Percio will discuss the different types of conflicts that may arise in estate planning administration, and will show you some scenarios where the conflicts can appear. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So first, I'm going to start with a brief overview of conflicts. What is a conflict? The definition of a conflict is that it arises between an attorney and a client if the interests of the attorney, a different client, or a third party conflict with the interests of the present client. So there's a couple different types of conflicts. There's concurrent/successive conflicts. There's direct conflicts. That's where two clients are directly at odds with each other. That one's pretty easy to spot. Some of the other ones, not so easy. Then there's indirect conflict, clients and third parties. And then there's, lawyer-client duties to third parties. For instance, a duty to beneficiaries, that is under a will. Then there's imputed conflicts. So where an attorney, moves from one firm to another, if that attorney gets conflicted out, so does their firm in some cases. There's ways to wall that off. We'll talk about that. But that can often be a problem, particularly where, local counsel is moving around and, it's a small town or a small city where there tends to be a lot of interrelation among parties that might be adverse to one another, represented by local firms in the area that attorneys move around to. So, jumping into this in a little more detail, a concurrent conflict is when you represent two clients at the same time whose interests are directly adverse. So Rule 1.7 and the DRs deal with this, the disciplinary room rules deal with this. Successive conflicts, again, these are fun to try to find and really frequently come up in the estate and trust space. That's where you've once represented a client, and now you want to represent someone whose interests are directly adverse. So this is looking at what are your duties to former clients, or clients you have that may still be a current client, but you haven't spoken with in quite some time. And also, when do you know when someone's a former client or a current client? All good questions to ask. Rule 1.9 and the DRs deal with this. Then there's direct conflicts. Again, these are easier to spot. You can't represent Pepsi and Coke at the same time. That's where your interests are directly adverse to that current conflict, whether that's through someone that you're representing or your own interests, if you're, part of the Coke family, say, so to speak. Indirect conflicts, that's where you have some other interests beyond the duty of loyalty to a client. Actual conflicts, you represent a client in a real estate matter. Another client comes along and wants to sue your client in a landlord-tenant case. That's an actual conflict. Imputed conflicts, again, that's where you have firms, you have to wall off data sometimes if you're moving from firm to firm, and there's conflicts between existing clients or former clients at the firm that you're moving to or leaving, and the client that you're bringing with you there. The larger the firm, the bigger the issue. For those of you listening who work at large firms, you know how annoying that conflicts process takes. It takes, at a small firm, you can get an engagement letter out in a day and start working on a client matter. At a large firm, it could be months in some cases I've seen. So always still important work, but can be a real pain in the neck on the imputed client side. Personal clients, these are conflicts that are personal to you, but not to your work as an attorney. So for instance, you're going to litigate against your spouse. Imputed conflicts, these conflicts can't be imputed, and these personal conflicts are dealt with in Rule 1.10. Okay, so now we're going to talk about the typical scenario in a trust and estate practice. So, often this is going to arise when you're representing multiple family members and, you're serving in dual roles. Say you're both the attorney that's hired to work on the estate administration, but you're also the trustee or the executor. So you're sort of advising yourself on how to do the work and taking fees for both. So that's one way that you have a conflict. And I want to just mention quickly, and we're going to talk about this quite a bit, the presence of a conflict does not necessarily mean that you can't do the work. The presence of a conflict means that you have to address that work, and you have to address that conflict so that you can do the work. There are some cases where a conflict is waivable. There are other cases where a conflict is not waivable. We'll get into that in a moment. So you most certainly, in most states, it's accepted. It may not be best practice in most states, but it's fairly frequent in most places that I've seen, where you have many attorneys who are sitting as both the law firm for the administration, whether it be an estate administration or a trust administration, and they're acting as the fiduciary. So it's a pretty common thing to see. Again, it's not, pro se, or trying to think of the exact word, prima facie malpractice, will you? Certainly not. But there is some essence of a conflict there that is, again, waivable by that estate's beneficiaries. Those people you have a fiduciary duty to protect, both as the fiduciary of the estate, the executor, or the trustee, and then your fiduciary duty to them as to yourself, really, as the attorney for the executor or trustee. So there's some, essence there of a conflict that needs to be addressed with those beneficiaries, to say the least. Other areas you see it are multiple family members. So if you're representing, this is very, very common. If you've been in the trust and estates world for some time, you work with mom and dad, then you work with their children, you're doing estate plans for everyone, everything's hunky-dory, everyone gets along, you're not so worried, the work seems very separate, in that you're drafting a separate estate plan for, that young family with a new child, and then you did their parents' estate plan as well, and they own a family business, say. Now one of the parents passes away, and you now have, two quote unquote clients that, may not be in direct conflict with one another, but, there may be some outcomes that say that child doesn't like, but you represented them on the planning side. So you have to be really careful in your engagement letters, which we'll get to really hone the scope of your work as an estate planning attorney. One note on representing spouses, and this sounds dramatic, but it actually comes up fairly frequently. So this is when, you have confidences imparted by one joint client. I've been in many situations where you've had one spouse want to change part of their estate plan or is contemplating an issue with their marriage that they're not sure is workable. And you're representing them jointly, doing a joint plan for a married couple. You now have a conflict because this information that one spouse, imparted to you in confidence, that the other spouse does not know, is not aware of, that affects your ability to effectively represent them as a joint couple. You informing the client, the other spouse or the clients as a joint unit of this conflict can lead to issues for the clients. So really important that when you're drafting your engagement letters to joint clients, you're taking this into account and being very clear upfront with clients that if they're going to tell you, hey, I plan to, leave my spouse in 5 years after our kids turn 18, I want to make sure they have less power over my estate plan than maybe I said in the meeting. Really important that you make it abundantly clear at your consultation meeting with them that if they're sharing things like that with you, that's going to create an ethical conflict of interest to you representing them jointly, and that will need to be disclosed, or you might stop representing them, which is going to raise questions and maybe affect their plan, to leave in 5 years and things like that. So all things that are just important to keep in mind. A lot of these issues can get addressed and are quote unquote, if not weavable, addressable, so you don't find yourself in a pickle trying to, figure out how best to navigate a somewhat hairy situation. Because as an estate lawyer, as I say time and time again to so many other trust and estates lawyers, this is messy, very personal work. You're dealing with someone's entire livelihood. When you're drafting an estate plan for someone, it's everything they worked for their whole lives in many cases, whether it's a probate asset that's going through a will or a trust, or it's just naming a beneficiary on an account. That's personal stuff. And they may have specific beliefs. It comes down to their philosophy on spending and budgeting, their relationships with their closest family members, whether that be their spouse or their children, or those relationships of their family members with each other, even if they're somewhat neutral. So really important to note that, it's an area where there's lots of conflict, and, definitely never think this work is simple. I always like to say there's no such thing as a simple estate plan. I've literally never seen one. Would love for someone to send me one and probably point out why it's not simple, or learn about the situation and tell you why it's more complicated than you think. So again, just important to note that this work can be riddled with conflicts. A lot of it you can mitigate, though, and protect yourself from and your clients. Okay, so conflicts, why do they arise? Conflicts arise for a bunch of different reasons. It's not always the soap opera I just described to you. Often it's just you have a new client come in, and you're looking through your list of prior clients, and say they your firm has multiple practices, and say there's a commercial litigation practice at on the other side of the firm, and you're in trust and estates, and that client was involved in some consumer class action suit against a company that your client represented. So things come up frequently. Or say you're representing business owners, really common in trust and estates. We can keep it to just purely a trust and estates practice. And one business owner now said, "Oh my God, you're the best lawyer I've ever had. I want you to represent my business partner too." Things are copacetic between them and the business partner now. Is that going to create issues down the line? Again, all things you have to think about when you're drafting your engagement letters for all of these people, really. Divulging facts to an expert so that they can't represent the other side. That's another way a conflict of interest can come up, a pretty not great technique to use. New matters with an existing client. It may not be that the client's not a new client, but rather it's a new client matter that you're working with them on. Say you're working with, a real estate owner or professional, and they are buying a new strip mall, and you did their estate planning, and you work with them on the tax side of these kinds of transactions. But that, you've worked with this client in the past, but it turns out you represented one of the leaseholders within that, one of the tenants that is under the current owner. That could be a conflict. So again, all things that need to be checked out and looked at as you're doing different types of work, or even just doing trust and estates work for people exclusively. New issues in a litigation can cause conflicts. New parties entering litigation midstream via an impleader or joinder. New attorneys joining your firm. And I gave this example earlier of if you're in a smaller city or a small town or just small region, oftentimes new attorneys carry new baggage in terms of they have their book of business, you have your book of business, and it turns out you have some conflicts within that need to be sorted. Relationships with adversaries, also important. Lawyers becoming a witness to things. You might have done the estate planning and now someone passed away, and you're being brought in as the witness to the testator's state of mind. That certainly can come up. Or lawyers having an adverse financial interest, always another interesting one of where, oftentimes, lawyers can, be invested in something, and maybe they're working with someone who has an investment partnership, that conflicts with your personal financial interest. So important to just note there. Maybe they want to sue a company you're an investor of or something like that. That's another sort of more straightforward example, but you get the idea. So most commonly, new client is a big reason for new conflicts. So estate lawyers, we often represent families. Conflicts of interest can prohibit representation of multiple family members. This is common in the estate context. And most common example is you represent parents as their longtime counsel, and now the children and the would-be beneficiaries of the parents' estate want you to represent them. These are waivable. So, for instance, if conflicts between competent parties are not substantial and common interests prevail, the lawyer can jointly represent them or concurrently represent them and act as an intermediary. So really important to keep in mind. So one thing to note is if you're representing a corporate fiduciary like a trust company, you should discuss potential representation limitations given the other people that you represent in your planning practice or just in your T&E practice generally. Without an agreement, a lawyer representing a corporate fiduciary in an estate administration doesn't represent the fiduciary generally in unrelated matters. So it shouldn't stop you from, if you represent, JP Morgan Chase Trust Company of Delaware, for some reason, you're helping them as local counsel in an area where they're trying to administer an estate. It shouldn't stop you dead in your tracks, barring anything, any exceptions from representing a party that's maybe suing JP Morgan Chase in, some other unrelated lawsuit on a different side of the bank. That shouldn't cause, an outright conflict that needs to be waived. Those are generally separate and distinct enough from one another, but, important to just make note of here. Definitely check your local state's rules if you are starting to work with trust companies and represent them in a certain context or in a limited context, and limit the scope of those engagement agreements, obviously. Some examples of things that are not waivable. Some conflicts are so significant that informed consent is not going to rectify them. You can't just disclose the conflict to them and they can just say, oh, I don't care, and that's fine. These are non-waivable conflicts. Lawyers cannot represent clients with interests that are in severe conflict, right? If you're suing each other, can't represent, and be on both sides of that lawsuit. Another probably better example in the trust and estates context is prenuptial agreements. I'm sure many of you out here who practice in this field do credence. You can't represent both spouses there. Each spouse needs separate and independent legal counsel. So important to note, you might do their estate planning later on, or say you need to adjust their prenuptial agreement because you're doing something in their estate planning that might mess up one of the obligations they have to one another. So you may need to do a postnuptial agreement. You can't represent both of them in that postnuptial agreement. You need to bring on another attorney. So just important things to just keep note of that will help you down the line and protect you from these issues going awry, which they can and will do.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.